Alright everybody, I'm Tarhaka, I'm back. And today we're going to do part 4 of our secured party, creditor, status. And we also have some documents for you. We're going to deal with the history of the secured party, creditor, and all this stuff. So y'all bear with us. We'll start off right here. Right that there. What we want to accomplish today is to give you some insights on the inner workings of a secured party and creditor. We want to get all the information, all the basics, all the background, everything that we can possibly get to you on this particular segment. This is part 4 of our series of videos that I told you about. We got documents that we're going to bring to the table for you. And let's see which one we can. Okay, we'll be consistent with that right there. Okay, but without further ado, let's get started. Okay, y'all hold on.
Well, hello. Thanks for joining me. Today we're going to talk about changing legal status. This is Mark Emery. I'm the founder of the Lighthouse Law Club. Most of you know who I am. Those of you who don't, stick around. You'll catch up quick enough, I'm sure. This is a members-only webinar, and we'll be sharing part of it with the public. And we're going to be getting into, again, changing legal status. You know, the one thing that I really enjoy the most about the Law Club is having the opportunity to speak personally and directly with each and every one of you, you know, as you come along. And there are so many fascinating stories, so many fascinating personalities. I just find it a real joy to share the energy that we create in putting some great minds together. And in that regard, there seems to be a common theme with most everybody that I talk to. And that common theme is that we recognize the mess that we're in by virtue of how we've been suckered into contracts without full disclosure and lack of informed consent. And we've been suckered into this legal status that we need to get out of, and we need to change it to get back to our natural, God-given, inherent state of presence so that we don't have all of these interferences and intrusions and compelled performance statutes intruding and imposing themselves in our lives. So that's a common theme, and so let's get into it. Now, there's a lot of folks out there doing different things. That's really great. As one individual, you can only do so many things, same with myself or anybody else. And the fact that we're all having different experiences is something that we can draw on and gain strength from. Now, where I'm headed with this is real simple. As it relates to changing status, there are some very advanced legal technologies out there that get into some very exotic types of paperwork and processes. Becoming the secured creditor on the bond created by your birth certificate. That's a fascinating process. I'm fascinated by it. I haven't done it myself yet. And I think it could very well be very effective under the right circumstances. We're not going to talk about that tonight. Tonight we're going to stick to practical measures for moving to the private side and living a private life. These are practical things that you and I can do in short order without getting wrapped up in all kinds of fancy legal documents and legal mumbo jumbo and extended processes and interactions and waiting for responses and all of that kind of thing. Again, as valuable as that may be, but as we go along here today, you'll find out why it's important that we do much more than that. And if we don't take care of the practical matters first, then all your fancy legal paperwork isn't going to mean diddly squat. All right, you're going to see that. So let's take a few minutes, just review some of the basics. Most of you, I'm sure, have the basics under your belt. but it's important that we establish this review so we have a solid foundation to proceed on, and that those who are just coming along, just getting on board with some of this type of information and training, that they can come along with us and catch up with us real quick so that we're all on the same page when we get to the finish line. Okay? So let's jump right into it. Let's compare the private side with the public side. We can see that in the beginning, God created man. We'll call him John Michael Smith and everyone else, right? That's where it all started. He gave us dominion over the earth, and he blessed us abundantly. Based on what? Our covenant with him. He later gave a covenant to Moses. What's another word for a covenant? It's a contract. Our blessings were premised upon the fulfillment of our end of that covenant. If we failed in the contract, guess what? The blessings would be withdrawn, and we'd have our own devices to deal with, and the results that come from that. And here we are. All right, so contract law you will find throughout the Bible, and this is where it all comes from. With that, we have natural rights. Rights are not something that anybody can give you, but rights are something that nobody can take away. Those rights include the right to free travel. If we have dominion over the earth, we come and go as we please. We ingress and egress. We don't need to pay someone for permission to travel. We have the right to be left alone, to live our own life however we want to live it, believe whatever we want to believe, be as weird as we want to be. And so long as we don't impose or trespass upon the rights or property of someone else, there is no crime, there's peace, and we live our lives as we see fit. We have the right to self-defense, the pursuit of life, liberty, and happiness. If you understand history, when our founding fathers were writing the Declaration of Independence, there was a great debate over what word should be used. Should it be property or happiness? Initially, the phrase was the pursuit of life, liberty, and property, because one who has the right to own, claim, and use property is happy, and so that embodies happiness. And so there was a great debate that, one means the same as the other, so we can use that term property interchangeably. So we have the right to pursuit of life, liberty, and property, or we can say we have the right to pursue life, liberty, and happiness. So man created state government to regulate his affairs and to serve him, so that we'd have halls of justice, we could have some order, we'd have some agreed upon rules that we could all live by, so that we could all live with increased security and more prosperity, so we could do business and live. So state government was created to serve man. So as the states sprouted up in the history of the United States of America, there were 13 colonies who evolved into states. Those states started having different currencies, different rules, and the conflicts increased as each state kind of went about its own business in a little different way. And so with that conflict, that level of conflict growing, it was imperative that the state governments get together and create a federal government to help unify standards and protocols and to better manage the intercourse between the different states, so things would run a little bit, or if not a lot, more smoothly. From this point, administrative agencies were then created to help both the federal and the state governments administer their affairs, just helping take care of the administration of the business that was intended. So here we see the hierarchy. Look at who's on top, where this all started. This is the hierarchy of order. Everything starts with God. God created man, gave him dominion over the earth, Man serves God, and man is the top man on the totem pole in the physical world here on the earth. State governments serve man, federal governments serve the state governments, and the agencies work for everybody else. And this is the hierarchy of order. This is the private side. This is the private side where man is the sovereign, under God, of course. So long as we maintain our covenant with God, we maintain those blessings, we maintain our dominion over the earth, we are blessed abundantly in everything that we do, and things proceed along the lines of a life of freedom, liberty, life, liberty, and property, right? So let's look at the public side. On the public side, the government creates John M. Smith. This is not the John M. Smith that was born and created by God. This is a different John M. Smith. This is a fictional entity, just like a corporation is a fiction. John M. Smith, all capital letters, is a corporate entity. It's a fiction. All right, so now that this is created, the federal government has dominion over the state governments due to the money powers and many other things. It also has dominion over John M. Smith. Those federal administrative agencies also have dominion over John M. Smith. And John Michael Smith doesn't know any better, so he identifies himself as John M. Smith, responds to the mail, and acts as though he is one and the same. And all of a sudden, he no longer has dominion over the earth. In fact, not only does he not have dominion over the earth, he doesn't even have dominion over himself, or his house, or his land, or his kids. The government owns him and is telling him what to do, what to buy, what kind of insurance to have, how much to have, what kind of cars to buy, where to put his kids, how he should buy his house, what kind of standards his house needs to live up to. He doesn't have dominion over his land. Look at what the BLM is doing to the ranchers, kicking them off their land, stealing it, burning down their houses. We don't own land. And you certainly don't have dominion over your kids when Child Protective Services knocks on your door and takes them away just because they can. So the question comes down real simple. What side of the law would you like to be on? It's pretty obvious why so many people are catching on and wanting to move over to the private side, right? It comes down to a hierarchy of order. Do we want to live in a land where federal and state governments have dominion over us? We don't have any God-given rights? Or do we want to live where man is sovereign, in covenant with and under God, where we have the freedom to live our lives as we see fit? And we have the governments to serve us and to maintain stability and security and nothing more. So the choice is quite obvious, right? So that's why we're moving from the public to the private and changing our legal status. How do we get suckered into all this? I know most of you are aware of this, but let's just review it real quickly. All right, the birth certificate for John M. Smith is created. When he is born, he is taken from the water. When the water breaks from his mother, he is delivered upon the land. The baby is delivered from the water, admiralty, delivered upon the land. A certificate is created, as in a bill of lading from the ship's manifest. The ship is the vessel, which was the mother. Again, bringing admiralty from the water upon the land. The certificate indicates that there is ownership over John M. Smith, but it is not the title. It merely is evidence of the existence of a title for John M. Smith. So that's where things start. Social Security, we're told we need to apply for a Social Security card in order to get a job. We all know the story behind that. It's a big lie. The law itself says it's purely voluntary. In fact, there was a lawsuit with the Equal Employment Opportunity Commission when someone objected to being forced to put a Social Security number on their job application with Taco Bell in order to get a job. And they won that lawsuit. They were not required to put their Social Security number to get a job. But the point here is that the application, when you sign that as true, complete, and correct, and put your authenticated signature upon that application for contract, that application is full of admissions and confessions, just like all federal documents are. You admit to being a United States citizen. Well, at that point in your life, when you're a 15-year-old kid, chances are you were a state citizen and not a federal citizen. So, there's all kinds of ramifications on that. We understand that. All kinds of admissions and confessions that are not true. It's fraudulent inducement, lack of informed consent. You didn't know what you were signing. Okay? It's based on fraud, and we'll talk about that in a minute. Now, Federal Reserve notes are promises to pay. That's what a note is, promissory note. So our currency that we're exchanging every day are promises to pay, which never get paid. In fact, since the United States became bankrupt in 1933, there has been no lawful payment done since that time. We've been exchanging credit and negotiable instruments. And since nothing is paid by law, because there is no lawful money in circulation, what we're doing is we're exercising the franchise, which is the privilege of discharging debt. The privilege of discharging debt is not lawful, but it is public policy. So we're not operating in law, we're operating in public policy. And the public policy is, since you never paid for anything, you don't own anything, which is why the government can come and take anything from you whenever they want, because you don't own it. So, we won't get into that, the whole money issue. That's something that needs to be understood very well, if you don't already, and many of you do. Corporate employment is a key element. One of the first things the judge will ask you when you step into court, okay, and are you employed? Where are you employed? Oh, well, I'm a warehouse manager over at Home Depot over on Lincoln Avenue. Okay, very good. And where do you reside? Oh, I'm over here on 910 Birch Street. Okay, so the judge says, so you reside and you're doing business in the state. Thank you very much. You've just granted me jurisdiction. We will now proceed against you. Corporate employment is very problematic. We'll talk about that as we get into some of the details, but you need to be seriously thinking about doing something about that. And again, we'll get into that in just a minute. But those are federal benefits. Corporations are creatures of the state. When you work for a creature of the state, exchanging your services for promises to pay, which are issued by the Federal Reserve, a private corporation, you are so deep into commercial law and federal regulation, it isn't funny. All right, so that's something we need to be careful of. Being a resident. All right, let's break this word apart. I get into this in my workshop, The Private Traveler. Res is the Latin term for the thing. Ident is the root for identified, right? So resident is the thing identified. Identified as what? Identified as property, inventory, chattel. You understand? Because you're identifying yourself with John M. Smith in all capital letters, you are owned by the state. So again, that's why the judge asks you right off the bat, where do you work and where do you reside? All right, you better have a good answer for that. Do you have a bank account? Well, you ask, well, how could having a bank account set me up for receiving federal benefits. If you've got a bank account in your name, your signature is on the account, you've accepted all the terms of the bank, and even though the bank may have a state charter, it's a state chartered bank, it does have FDIC insurance. And so you're receiving benefits from the Federal Deposit Insurance Corporation. So there's your federal benefits right there. Insurance contracts. The state requires John M. Smith to have various insurance contracts. He needs to have automobile insurance, he needs to have health insurance, he needs to have business insurance, liability insurance, right on down the line. Insurance contracts are interstate compacts. They're interstate agreements. They derive from maritime jurisdiction. This brings us right into commerce, which brings us right into federal regulation. And that's a whole subject we could get into, but we won't. Okay, you know about the driver's license and the marriage license. What is a license? A license is permission to do that which is otherwise illegal. So that begs the question, well, geez, when was it ever illegal for me to drive my grandma to the church? Well, just by virtue of the fact that you do not understand language, we can see that by virtue of the fact that you're using the term driver, that you are a driver. You're applying to be a driver, and therefore you want to get licensed. Driver is a commercial term. We have taxi drivers. We have truck drivers. We have private chauffeurs who are drivers. We have postal carriers who are drivers. We have package delivery people that are drivers. This is all commerce in transport. These are commercial terms. Now, if you're not engaged in commerce on the roadways and the byways, then you are not a driver. Therefore, why on earth would you apply for a driver's license? You've always had the right to travel, and people are learning this, and they're learning how to do it successfully. So, again, you were fraudulently induced. Nobody told you about that, so you applied for commercial privileges. When did it become illegal to get married? The marriage license actually originated, I believe it was back in the 1800s, when they made it illegal for interracial marriages to happen. All right? They didn't want the slaves marrying the non-slave class. And so the license was required. And then the practice grew, and all of a sudden, what you're doing now is you're taking a right and converting it to a privilege granted by the state. When I got married, I didn't use a marriage license. I found a pastor who would do it without one. Not all of them will. So what happens when you apply for a marriage license? You're bringing the state into the marriage as a third party, just like your spouse is. So the state is now has equal standing as your spouse does in that marriage. I was talking to a gentleman from Montana, and he looked at the back of his marriage license, and it stated very clearly that the product of this marriage belongs to the state. Well, think about that. What's the product of a marriage? Children. Are you starting to get the picture now? These are very serious issues. So these are some of the benefits that we apply for, and we get sucked into these contracts. In doing that, really we violate the covenant that we had with God. And so we move from that jurisdiction, we get sucked into another jurisdiction, which is highly regulated and generates fees, fines, all kinds of forms, and we could go on and on. All right, so this is what traps us. Let's take a look at this. The private Federal Reserve Bank. Look on your dollar, your Federal Reserve notes. You see that E on the left. That E signifies the issuing bank, the bank that issued this Federal Reserve note. And E happens to stand for the Federal Reserve Bank of Richmond, Virginia. Okay, so when we see that E, we know which bank owns this promissory note. And if they ever decide to claim it, it's theirs, they can come and get it. Okay? So you see that same E in the serial number, which again immediately identifies the issuer. The issuer is the owner. Now, we can see also on the back of the Social Security card, this number is not the Social Security number. There are many people out there that know more about this than I do, but they'll tell you that this is the registration number or the bond number representing the bond that's created by virtue of your application for the Social Security card. Now, how could they create a bond? Well, when you apply for the Social Security number, what are you doing? You're saying, I want you to take so much money out of my check for the rest of my life on the hopes that maybe I'll see some of it back when I retire. Think of all the money that someone generates, not only in terms of withholdings, but taxes paid, all the different types of taxes that are paid. I saw a list of all the taxes that are paid, and it was pages. I mean, there were hundreds of different types of taxes that we pay. And so think about how that adds up over someone's lifetime and as a part of their earnings. And when that compounds, and when you can use leverage with the fractional reserve banking system, how you can take $1, make it $10, lend that out again, and do it over and over and over. It becomes exponential. So we can see that this account is owned by the Federal Reserve Bank. This account is in the name of John M. Smith, and you identify yourself as John M. Smith, and therefore you're obligated to this account to continue paying for the rest of your life. So isn't that sweet? Okay? Just something to be aware of. So, the IRS is a private collection branch for the Federal Reserve. That's what they do. They collect for the private Federal Reserve. Now, take a look at this. The IRS doesn't collect money for the government. They're a private trust domiciled in Puerto Rico. And you can look it up yourself. Let's read this. In 1953, the Internal Revenue was created by the stroke of a pen when the Secretary of the Treasury changed the name of the Bureau of Internal Revenue, Treasury Order number 150-29, G.M. Humphrey, Secretary of the Treasury, July 9, 1953. However, no congressional or presidential authorization for making this change has been located. So, the source of the authority had to originate elsewhere. Research to which IRS officials have acquiesced suggests that the Secretary exercised his authority as trustee of Puerto Rico Trust number 62, Internal Revenue. And you can see this in Title 31 of the U.S. Code, Section 1321. Look it up yourself. And as will be demonstrated, the Secretary does, in fact, operate as Secretary of the Treasury, Puerto Rico, which is a territory. It's not even a state. Puerto Rico, as a territory, is managed by the United States in Washington, D.C., the corporation. United States, the corporation. Now, one thing you may not be aware of is that the Secretary of the Treasury of the United States does not receive his paycheck from the United States federal government. He is paid by whom, do you know? By the IMF, the International Monetary Fund. So, what's this telling us? The treasurer of the United States is paid by foreign interests. The people you pay your so-called taxes to in the IRS, that money actually, well, number one, doesn't even touch the floor of U.S. government offices. So if you think you're paying for roads and bridges and schools and health centers and justice systems and armies and military and everything else with your taxes, I'm sorry to tell you, not one penny is going to anything that benefits the people. It's going straight into a private trust, which is managed by a combination of the IMF, a federal corporation known as the Federal Reserve Bank, and that ultimately ends up with the Queen of England or the Vatican. So, you want to pay your taxes? That's your choice. It's entirely your choice. All right? So, you say to yourself, well, crap. I'm not going to do that anymore. I'm not going to pay my taxes if that's where it's going. Well, I'm sorry, but you're hooked. You're hooked by the agreements that you've made. You've made admissions and confessions in the applications that you've signed that you are a charter member of this corporation known as the United States. Nothing to do with the government. And you're regulated by commerce, you're engaged in commerce, you're wrapped up by contracts, and unless you do something about that, you're stuck. You're hooked. You're not getting off the hook. We've got agreements in place. So this is the dilemma that we find ourselves in, right? Let me give you some resources right now. Having said that, it's very easy to rid yourself of the IRS. It's very simple. I should say it's simple. Not always so easy, but it is simple where you can do it safely and securely and not go into any level of risk. And I show you how. We start number one. You need to get, if you haven't already, get this free download. I wrote a book called How I Beat Satan and the IRS. You can get it free. Go to the onefreemanswar.com. Go to the Defend America page. And all I ask in exchange for this free book that I'm giving you, I want you to share it with at least 2 other people. And get their commitment that they will share it with 2 other people. If we can get this to go viral, we can expose the fraud in the country. We'll know what's going on. So, get your free download there. Then once you've gone through this, it's a short read, it's a quick read. It's only about 62 pages and a lot of white space, a lot of quotes. There's about 10, 11, 12 chapters in there. Each chapter deals with a different element of the IRS fraud. Makes it very easy to see. It's not hard to read at all. It's not full of a lot of legalese. Should be quite entertaining and informative. But participate in the Defend America program. Get the word out. Share this link with people you know. And then once you want to do something about it, we have an IRS Freedom Package that provides supporting documents and the processes to put a couple of these most important strategies to work where you can safely and securely simply walk away. Okay? It's pretty simple. Now, I would also recommend a video workshop that I've done that will get into some more detail and lay some things out. And it shows the only 2 roads that the IRS travels on. And if you can block those 2 roads, there's nothing they can do. What you do is you make yourself immune. And it's real simple to make yourself immune. And if they can't throw you in jail, and if they can't take your stuff, your bank accounts, your house, your property, position yourself so they can't do that. If they can't touch your stuff, and if they can't throw you in jail, there's nothing they can do. They can holler and scream all they want. Okay? But the previous taxpayer is going to show you how to do that. So that's video on demand, and that's, I don't know, about 90 minutes, maybe a couple hours maximum. And you'll find it there at that link. So those are a couple resources right off the bat that you have that I'd be happy to share with you. All right, so we got to get the IRS out of our lives. And you need to understand that fraud vitiates all contracts. And that's coming straight from the U.S. Supreme Court. It's a maxim of law that goes back before the country was ever created. It goes back many, many, many generations. You know, the Supreme Court said in Throckmorton versus the U.S., the maxim that fraud vitiates every proceeding must be taken. In other words, they could not ignore the fact in this case that the entire case of the defendant was based on fraud to start with, which means that everything that proceeded from that was null and void. You know, it's fruit of the poisonous tree doctrine. If the tree is poison, the fruit is poison. And you can't go beyond that. So it starts with contracts. So we go back to all those contracts that you signed with the Social Security application and those type of things. And there's a process for basically putting the people, the counterparties to those contracts on notice that you have uncovered their fraud, you know what it is, you are stating the fraud, you are putting them on notice that you are no longer participating in the fraud, and that you consider that original contract null and void, nunc pro tunc. Okay, now for then, as from the beginning. So that's a fundamental issue. And so we have to get into understanding a very simple concept. A lot of people are rushing around doing paperwork, and then they're hauled into court, and the judge asks those key questions. Where do you reside, and where do you work? And people are flashing around these fancy documents. Oh, but I got this, and I'm sovereign, and those laws don't apply to me, and I don't consent, and all this stuff. And the judge just, takes silent judicial notice of certain things relating to substance that can be obviously seen, and you have neglected to cover those because you're more concerned about your documents, which are the form. All right, this doctrine, substance over form, really comes originally from the bookkeeping and the accounting world, where people may structure certain transactions in a way to minimize or avoid entirely taxation. And there's nothing wrong with that, provided that their activities are substantive and real, and the relationships involved in those transactions are real relationships, real people or entities doing real business. So you've got to have the substance, and that's what we're going to talk about tonight. We're going to talk about practical issues on how to create substance so that you don't stumble over your own form, your documents, your filings, and end up nullifying all of that because the substance just isn't there. Case law from this doctrine has stated that in order for the mortar to work, there must actually be bricks. So the bricks are the substance, okay? The mortar is the form. You got to have real bricks going on here. All right, so what I'm saying is that your behavior, the way you live, the things you do must match the assertions that you're making. You can't just say, oh, I'm a private individual, I'm not engaged in commerce, look at my documents. Okay, when the judge can see right off the bat with a couple simple questions that you are still engaged in commerce, you're still receiving federal benefits, and you're just as much a slave as you ever were. Because the documents don't do anything if the substance isn't there. And so that's what we're going to get into right now. We're going to get into some of those details and figure out how we can be practical and move to the private side, perhaps without even needing all these fancy and exotic documents and processes. Okay? I'm just a practical guy. I like to go with what works, and this is what's worked for me time and time again. Okay? Now, the details that we're going to cover, I've listed at the end of my private traveler workshop. And the private traveler really establishes the fundamental legal elements that are necessary to understand when moving from the public side to the private side. Okay, so this establishes a very good foundation. It's an on-demand video workshop that's available at this link. At the end of this presentation, I go into a list of these practical items. I cover the list, but I don't really get into the details. So what we're going to do right now is we're going to get into those details and dig into what it takes actually to have some of these practical issues resolved in your favor, so that you've got the substance. Once you have the substance and are living on the private side, then is a good time to go and pursue the documentation, the legal processes, the liens, the trademarks, the copyrights, whatever it is you want to do. Okay? So from this point, we proceeded in the web conference complete version that our members were a part of. For the members web conference, we proceeded to review a list of about 20 different practical items. We covered each one in detail. These are things you can do to separate yourself from the behavior of federal citizens. These are practical issues that increase your privacy, that will change your visibility and status as a resident. And it's quite fascinating that as you begin to implement these points, you eliminate the accoutrements of federal subject citizens. This is extremely important because whenever you find yourself in front of a judge, for example, or dealing with officialdom, they are trained to take silent judicial notice of certain facts, certain elements, things you say, your behavior, things that appear in your paperwork. These are all the elements that we need to work to eliminate, if in fact you really do want to change your status back to the private side. In the complete web conference that our members were involved in, we went over these in quite some detail and at length in a step-by-step process. This video is for public purposes and is not the complete video that our members have access to. So, that being the case, once these things are accomplished, you cannot be mistaken as a resident doing business in the state, which are the first two elements that any court or judge will try to establish in order to get jurisdiction over you as a fictional entity subject to federal status. Okay? These are all very interesting, very fascinating things, simple things that can be done, and quite interesting from the standpoint that once you can accomplish these things, everything changes and you're in a much more private and secure position. So, that being said, I would steer your attention to the website for the Lighthouse Law Club, and that's at lighthouselaw.club. In particular, I will steer your attention to the blog page. You'll find the blog link in the menu at the top of the page. And in the blog, we've got several videos, but I want to steer your attention to one in particular, and that is the vision of the Law Club, which will give you a good idea. It's about a 1-hour web conference that we had, and that'll give you an excellent idea as to really what the Law Club is all about and how you could participate and benefit from the activities of other members. The whole idea is to create synergy with all the activities that everybody is doing in different parts of the country, following different strategies, different activities in different disciplines. So browse the site, have a look around. We welcome you to join us in the Law Club. It's pretty painless, and we can do some great things together. So with that, I give you my best wishes. May God bless, and I hope to see you in the club with us soon. Thanks and take care.
Okay, everybody, we back. I hope y'all got something out of that legal status and change video. That was pretty informative. What we're going to do now is we're going to go down in some of these documents for you and lay some of that stuff out for you. So make sure that you got your paper and pencil handy, and don't forget, in order to get a hold to this kind of information, you go to www.newdataelimination.com. For our free report, go over to tarhakadataelimination.org. That's www.newdataelimination.com. for our secure party and creditor package, foreclosure killer, student loan, child support. We handle all that. But for our free report, that's www.tarhakadebtelimination.org. Okay, y'all sit tight. So we're finna bring in this stuff on these documents. We're gonna do about 4 of them, and then we're gonna go down into the history of the secure party and creditor. Okay, all right, y'all hold tight. Okay, everybody, our first document is the Common Law Vehicular Judicial Notice Constitutional Driver's License. Isn't that something? You get a look at it, and it states here that the undersigned common law citizen, whoever that is, hereby certifies by rights secured under provisions of the Constitution of the United States of America, the Constitution of the several states, common law, nature and law of nature's God, that these rights are retained in fee simple, absolute, and held protected with special regard to rights designated and slashed or set forth as follows. Also note, rights and property are one and the same thing. By the Honorable Justice Louis Brandeis, U.S. Supreme Court. Notice an advisory of rights claimed inviolate. 1. The right to travel freely, unencumbered, and unfettered is guaranteed as a right and not a mere privilege. That the right to travel is such as basic as it does not even need to be mentioned, for it is self-evident by common sense that the right to travel is a basic commitment of a free society to come and go from length and breadth freely, unencumbered and unfettered, distinguishing characteristics required by free people to exist. In fact, please see Shapiro versus Thompson, 394 U.S. 618. Further, the right to travel by private conveyance for private purposes upon the common way cannot be infringed. No license or permission is required for travel when such travel is not for the purpose of commercial profit or gain on the open highways operating under license in commerce. The above named common law citizen listed as not operating in commerce, and as such is thereby exempted from the requirements of license as such. Further, the state is forbidden by law from converting a basic right into a privilege and requiring a license and or fee charged for the existence of a basic right. Please see Murdoch versus Pennsylvania. Okay, and this goes on and on and on. This document is quite long, and I'm not going to read all of that, but I just want to give you a gist of what this thing looks like, and so you know what you're dealing with. This also comes along with our packages. Whatever you get, this come along with it, so you'll be able to exercise your freedom of right to travel. This is some of the same stuff that I used when I first did it. I was actually the first man in the state of Florida doing this. I don't know nobody else that was doing it. I'm definitely the first one right here in Duval County, here in Jacksonville. And me and the man Popo, we went round and round, and they was trying to figure out how to stop me, and I ended up having to send the sheriff an affidavit, and of course it scared the bejeebus out of him. He ran over there on the south side and hired a law firm as a go-between between me and him. However, I turned the tables on him and sent the law firm the same type of documentation that I sent to him. And of course, they panicked because they done looked up all the Supreme Court rulings, and there it is for them to read, and they didn't know what to do. Nobody had ever challenged this thing before, and this thing had major implications, and we're talking about massive lawsuits and all that. So everybody panicked. He gave us me in charge not to stop me anymore on the road. Just observe and watch what I'm doing, and but don't stop him, don't write him no ticket, because I put the affidavit together very, very well. In fact, it's inside my library, the same affidavit that I used on the sheriff. But anyway, I want to let y'all look at this thing so you'll know it exists, and this can be modified to suit you and the city or state that you live in. And there's much more to this other than this document. When you're talking about the right to travel, what we need from law enforcement is we need, because they ride around, they got computers in the car, they do an investigation on you. When your name pop up, everything in there need to say do not detain, do not detain. You opt out the contracts, and the cancel contracts don't exist. You contact the Secretary of State, you put everybody on notice of what you're doing. You've done your thing over the DMV, everything is in place, and we show you how to do all that. We tell you how to do it. So we just want to bring this out and touch on this particular document so you have that down. Okay? All right. Let's move on to the next document. All right. What is a secured party creditor? Let's find out a little something about that thing, man, before we get down into these plugs and stuff that we got for you. We're going to go over these documents. Secured party creditor is a term that is becoming more and more popular among the students of the sovereignty movement. And many different three-letter agencies are also aware of the growing number of people that are learning about secured party creditor filing processes and are feeling threatened by this because they will no longer be able to manipulate everything to their advantage and to our at our expense. It is important to understand that becoming a secured party creditor doesn't mean that you just file a UCC-1 and you're done. You must be very mature in your studies, as you will be tested again and again in your journey towards sovereignty. The same agencies that are feeling threatened are also very much aware that most people doing the so-called secured party creditor filings understand very little about correct process of establishing a secured party status and maintaining that status and doing the correct things with it to discharge debt. Okay, before I go on any further, let me make something perfectly clear, because we have a lot of people that are afraid of the word sovereignty, and the only thing that you have to do is look it up and you find out what that word means. But and then again, there is absolutely, and I got to stress this, it is absolute, there's no such thing as a sovereign citizen. Anytime anybody ever come to me with something about a secure, a sovereign citizen, I'll be like, man, what are you talking about? How you going to be a king and a slave at the same time? How you going to be a man and a slave at the same time? How you going to be free and enslaved at the same time? I mean, you can't do that. The word sovereignty, leadership, king, that's what that means. Secured party creditor over the trade name straw man. We must first understand that we all function through our trade name or straw man. The trade name is your business, and you as a living being function in commerce through your trade name. However, you are not the same as the trade name. This is one of the main purposes of establishing ourselves as a secure party. We must create that separation between the living being and the trade name straw man. Another purpose of the secure party creditor filing is to aid in the protection of all assets held in the estate, which is held by the trade name. The estate encompasses everything from the property to the bank accounts, etc. Now that we've established what the trade name is, we must establish what a secure party is and how one would use a UCC-1 filing. A secured party is one who holds an interest in a company's assets. They would record this interest in the public records by filing a UCC-1 financial statement. So if the trade name is a business, and we as the live beings hold an interest in the estate of the trade name, we must file a UCC-1 financial statement to give notice to the public that we have an alienated all property pertaining to the trade name. It is important to remember that the UCC-1 itself is not the lien. It is only notice of lien. The lien itself is established by the security agreement between the secured party and the debtor trade name. The security agreement is a private agreement which specifies that the debtor must perform as the transmitting utility for the secured party in commerce, in exchange for the secured party providing assets and collateral to the debtor. This would be called equal consideration. This agreement would also specify the sum of typically $100 billion as the security interest for the debtor to the secured party. The security interest amount doesn't have to be $100 billion, but it should be a high enough number to ensure that the secured party will always have the paramount claim of interest over all assets and property of the debtor trade name. To help you understand more, look up the secured party definition and other related terms in Black's Law Dictionary, Law Cornell Education, or other related good research sites. The filing of the UCC-1 is also important because it gives notice to all agencies, which means that no agency can compel the debtor to turn over any assets before first meeting its $100 billion obligation to the secured party. This is how all assets of the trade name can be protected by the proper use of the secured party creditor process. However, it is important to remember that the government and its agencies can change their policies constantly, which can potentially change the way we achieve our remedies. Therefore, we must not be attached to the secured party creditor filing as the only way to achieve freedom forever. This process may and actually should evolve as the policies governing commercial business evolve. Even though the agencies can change their policies at any time, whereby to change our manner of achieving our remedy, they can never actually take away our remedy. There must always be a form to achieve our remedy. We must have to continue to do our due diligence and learn to roll with the punches. Protecting assets is not the only thing that is accomplished through the secured party creditor process. We can also do what is referred to as securing our assets that are being held by the financial institutions and government agencies, such as loans, bonds, or tickets. Whenever we sign for something, such as when we sign a promissory note for a mortgage, what happens is that the banking institutions hold on to the assets which belongs to us and give us the liability side of the transaction, which is the obligation to pay. With the secured party creditor filing, we are placing ourselves in a position where we can either redeem our assets to close out the account, or we can discharge the debt to close out the account with House Joint Resolution 192. Now, we've already talked about the public law, so make sure anytime you see HR 192, always think in terms of public law. And the public law 7310, we have our remedy to either redeem our assets or discharge our debt. But we must first have the correct status established in commerce, since only secured parties can operate on the credit side of any transaction. Debtors can only operate on the liability side and must pay their obligation. So by what authority does one have to establish oneself as a secured party creditor or a trade name strawman corporation? In commerce, is it the one who provides the funding or the corporation that acquires a lien right against all assets of the corporation? In other words, when a baby has birth certificate issued against their flesh and blood body, the corporation is created, but it is the child that is in their lifetime will provide all of their energy funding for the corporation. Therefore, the child can eventually establish themselves as a secure party for the debtor trade name corporation and thereby secure all assets and collateral pertaining to that trade name. When the certificate of live birth is issued, it is done so without any face value, similar to a blank check. You know it has value, you just don't identify the value until it's time to close out an account. We do this by sending an indemnity bond to attach to HJR 192 along with our acceptance of the government's order in 1933 to remove all money of substance and provide our credit to that order to the Treasury to be held in trust for the value of $100 billion. This bond is to be used to discharge our public debts. All of this is done in accordance with the Uniform Commercial Code provisions. It is important to have a fundamentally accurate process for ease of enforcement. This process includes security agreement UCC-1 filing, a chargeback order, and even a common law copyright if you choose to get one. It is important to remember that this is a simple outline of some of the components of the secured party creditor filing. You may do your own research to ensure your process is complete before moving forward with discharging debts and redeeming your assets. Secured party creditor status also makes you an American national, state, national, republic jurisdiction. Okay? All right, that's pretty self-explanatory. Keep in mind that is another one of our documents that come along with what we provide for the people when we're trying to assist you in dealing with your secure party and creditor process. Okay, on to the next document. Okay, let's go on to our next document. This particular document was taken from creditors and their bonds. It's called "It Only Hurts When You Laugh." And I know a lot of y'all have probably seen this thing, but you need to pay close attention to the wisdom inside this document. This thing is pretty long. I'm not going to read everything from it. I just want to touch on it. I have yet to let me see. Do I have this book? No. I never did get this one. I guess because I had this document here so long. These are actual pages from the book, Creditors and Their Bonds. It's worth, especially if you are trying to be a secure party and a creditor, you want to have this under your belt. Every effect has a cause. Every cause starts with a thought. Remedy starts by changing your thinking. The laws of cause and effect. And let's scroll down a little bit. Every action generates force of energy that returns to us in like kind. What we sow is what we reap. And when we choose actions that bring happiness and success to others, the fruit of our karma is happiness and success. The 7 Spiritual Laws of Success by Deepak Chopra. No, I don't have that book. I got to get this and then add it to my collection. The laws under which we live operate to our advantage. All conditions and experiences that come to us are for our benefit. We gain strength in proportion to the effort expended. Our happiness is best attained through the conscious cooperation with natural laws. The laws under which we live are designed solely for our advantage. These laws are immutable and we cannot escape their operation. Difficulties, disharmonies, and obstacles indicate that we are either refusing to give up what we no longer need or refusing to accept what we require. All conditions and experiences that come to us do so for our benefit. Difficulties and obstacles will continue to come until we absorb their wisdom and gather from them the essentials of further growth. That we reap what we sow is mathematically exact. We gain permanent strength exactly to the extent of the efforts required to overcome difficulties. The Delphin system transforming the way the world thinks. Random House Dictionary. Okay. All right. This particular document is quite long. Like I said, I'm not going to read it all. I'll go down here and let's see. I'll get to the one that I really want to read here. It says here that an elder Cherokee Native American was teaching his grandchildren about life. He said to them, "A fight is going on inside of me. It is a terrible fight, and it is between 2 wolves. One wolf represents fear, anger, envy, sorrow, regret, greed, arrogance, self-pity, guilt, and resentment. Inferiority, lies, false pride, superiority, and ego. The other stands for joy, peace, love, hope, sharing, serenity, humility, kindness, benevolence, friendship, empathy, generosity, truth, compassion, and faith. The same fight is going on inside of you and inside of every other person too." They thought about it for a minute, and then the one child asked his grandfather, "Which wolf will win?" The old Cherokee simply replied, "The one you feed." Okay, I'm going to stop right there with this right here, and I just wanted to bring this out so you can make sure that you, if you get a hold of this document, read it in its entirety, and make sure you hold on to this thing. And this also comes along with our packages for people who are getting our secure party creditor. We give you everything that you're going to need to do that with. Your security agreement, your UCC1 financial statement, and we're here to assist you in the event you have any questions. Okay, so we're going to go on to the next document. Okay, so y'all hold tight. All right, now before we get into this one, I got to tell you about a situation that we have. This is a letter to the people that wrote the codes for the Internal Revenue Service. I had a friend of mine, and this guy, he was about, he was in his 80s, man, and he came to me and told me, he said, "Man, they took my property, and now they're trying to take my house, the house that I live in." And he said the IRS has also sent me a letter stating that I owe them over $45,000. And I said, "Well, look, we're gonna go to work on this here." So what we did was we started with Internal Revenue Service, then we started dealing with the property that he owned. But we sent a letter, and along with the affidavits and all the special effects and all of the law and everything to them. And they responded. They sent a letter back to us stating that if we would give them 60 days, they'll look over everything and verify everything, and they'll get back with us. Well, that was, it had to be about 5 years ago, and we have heard anything from them. Not one word, one letter, nothing else. They just like poof, vanished in thin air. And then we went on and went to work on them trying to fraudulently foreclose on his property. Okay, but I want you to take a look at this and see how this is constructed. Very simple and straight to the point. And like I try to tell people, when you are dealing with any company, if it's a credit card company, if it's a bank, if it's the sheriff's department, if it's no matter what company you deal with, and they claiming you owe them a debt, a car dealership, no matter who it is, you always want to deal directly with the people that are in charge. In this case, he dealt with the Mr. Peter Warwick, Mike Sims, Kathy Zappa, Senior Vice President, Mr. Tom Trinkner, Senior Vice President of Contact Operations, Mr. Richard H. Kane, Chief Operating Officer. And he dealt with all of them directly and made sure that they all got a copy of this particular letter. It starts out by saying, "Ladies and gentlemen, in 2002, I wrote your company regarding some 60 key case rulings of the one Supreme Court and their relationship to the IRS tax code, also advising Congress of these key cases. We also know the 16th Amendment was never lawfully ratified. See U.S. versus Roger L. Long, Federal District Court, AL case number 1-93-91. Should memory serve, see Attorney Larry B. Craft on Google search. There is no lawful tax code for these union states /states in all capital letter states. Why is your company aiding and abetting in tax fraud, tampering with evidence, and obstructing justice thereof? Congress guilty of high treason? Since 2002, how many innocent men/women have you, by intentional fraud, allowed to be put in jail because your company failed to revise the tax code? In the current tax code, how many key case rulings of the court are actually found? Is or is not your company the current publisher of the IRS code? Did or did not your company advise the courts of these union states of these errors? Who told you not to take further action in the matter to prevent further fraud upon the court? And he goes in and notice that the place here that he has a place for his name to be autographed in proper syntax grammar. We're going to get into that too as well, so you'll know how to write your name. Because when you write your name in cursive, or when you call yourself signing your name, that's called cursing. And you know, you want to deal with syntax. You want to be able to deal with that. Okay. All right, I just want to bring this to your attention, and notice down here it says closed caption FBI-Facebook as public record. Man, this is awesome what this brother did with this right here. Man, I want whoever that did that. But anyway, I just want to bring this out so you see this one right here, and we're moving on now. Okay, all right. I hope y'all got something out of this stuff, and I hope you're taking notes. And keep in mind, this is just a smidget of mere drop in the book at what goes along with our secure party and creditor stuff. Okay? All right.
Greetings, everyone. Today we're going to discuss status and standing. This is a continuation of our previous discussions. We are going to go over what it takes to live and be sovereign, what is keeping you from enforcing your inalienable rights, and dispel some myths floating around the sovereign citizen community. Our intention to this webinar series and our redemption secured party creditor process is to give you all the tools you'll need to remove yourself from undisclosed adhesion contracts, reestablish your status and standing as an American national and private state citizen, discharge debt and or settle claims properly, access the common law side of the courts, challenge jurisdiction, protect your property, and leave a legacy to your heirs and not Uncle Sam. Now, this webinar is packed with information, so let's get started. What is your status? Do you know where you stand in commerce? How about in regards to the law? Many Americans assume that their status and standing when it comes to the law, but many have been misled through lies, deception, fraud, and propaganda. Understanding status is essential. All individuals take a position at law and in commerce when entering into any contract or agreement. Under natural law, there is no limit to your rights and power to contract unless you waive or limit those rights by consent or tacit agreement. Your status plays a big role in determining your position when it comes to the enforcement of your rights and claims in commerce and at law. In order to understand where you currently are, it helps to examine relationships, circumstances, and events that got you there. Let's now take a look at how history has led us to where we are now today. Under the English feudal system, as practiced in the Kingdom of England, the state of human society was formally structured and stratified on the basis of land tenure and the varieties thereof. Society was thus ordered around relationships derived from holding of land, which land holdings are termed fiefdoms, fiefs, or fees. Under the English feudal system, several different forms of land tenure existed, each effectively a contract with differing rights and duties attached thereto. Such tenures could be either freehold, signifying that they were heritable, or perpetual, or non-free, where the tenancy terminated under the tenant's death or at an earlier specified period. Sestake, also sestuke or sestake, is a shortened version of a sestake use le fiefment fui fait, literally the person for whose use the fiefment was made. It is a law French phrase of medieval English invention, which appears in the legal phrases sestake trust, sestake use, or sestake vie. In contemporary English, the phrase is commonly pronounced setike or sestake. According to Roebuck, sestake use is pronounced sestake use. Sestake use and sestake trust are more or less interchangeable terms. In some medieval materials, the phrase is seen as sestake or sestake. In the Middle Ages, especially in the European feudal system, fiefment or enfeoffment was the deed by which a person was given land in exchange for a pledge of service. This mechanism was later used to avoid restrictions on the passage of title in land by a system in which a landowner would give land to one person for the use of another. The common law of estates and land grew from this concept. The sestake use is the person for whose benefit the trust is created. The sestake trust is the person entitled to an equitable as opposed to a legal estate. Thus, if land is granted to the use of A in trust for B, A is the sestake trust and B trustee or use. The term, principally owing to its cumbersome nature, has been virtually superseded in modern law by that of beneficiary and the general law of trust. The sestake use and trust were rooted in medieval law and became a legal method to avoid the feudal incidents or payments to an overlord, while leaving the land for the use of another who owed nothing to the lord. The law of sestake tended to defer jurisdiction to the courts of equity as opposed to common law courts. The sestake was often utilized by persons who might be absent from the kingdom for an extended time, as on a crusade, or a business who might be absent, or a business adventure, and who held tenancy to the land and owed feudal incidents to a lord. The land could be left for use of a third party who did not owe incidents to the lord. This legal status was also invented to circumvent the statute of mortmain. The statute intended to end the relatively common practice of leaving real property to the church at the time of the owner's death. Two conceptualizations, not mutually exclusive, of the term mortmain, which in French means dead hand, of the terms explain its origins. First, the dead hand may be characterized as that of the deceased donor and former owner to whose desire, as embodied in the testamentary provision that the church hold title to the property, remains subject. Second, because the church as a non-natural person recognized that common law never died, the land never left the dead hand or more accurately, the non-living hand of the church. Before the statute of mortmain, large amounts of land were bequeathed to the church, which never relinquished it. This legal arrangement was in contradistinction to others in which the land could be transferred to anyone, inherited only through a family line, sometimes sex-specific, or revert to a lord or the crown upon death of the tenant. Church land has been a source of contention between the crown and the church for centuries. Sestake use allowed religious orders to inhabit land, while the title resided with a corporation of lawyers or other entities who nominally had no relation to the church. Sestake v. Act 1666. Sestake v. remaining beyond sea for 7 years together and no proof of their lives, judge in action to direct a verdict as though Sestake v. were dead. If such persons or persons whose life or lives such estates have been or shall be granted as aforesaid shall remain beyond the seas or elsewhere absent themselves in this realm by the space of 7 years together, and no sufficient and evident proof be made of the lives of such person or persons respectively, and any action commenced for recovery of such tenements by the lessors or revisioners, in every such case the person or persons upon whose life or lives such estate depended shall be accounted as naturally dead, and in every action brought for the recovery of the said tenements by the lessors or reversioners, their heirs or assigns, the judges before whom such action shall be brought shall direct the jury to give their verdict as if the person so remaining beyond the seas, otherwise absenting himself, were dead. Section 4. If the supposed dead man prove to be alive, then the title is revested, action for mean profits with interest, provided always that if any person or persons shall be evicted out of any lands or tenements by virtue of this act, and afterwards if such person or persons upon whose life or lives such estate or estates depend shall return again from beyond the seas, or share on proof in any action to be brought for recovery of the same, to be made appear to be living, or to have been living at the time of the eviction, and that from thenceforth the tenant or lessee who was outed of the same, his or her executors, administrators, or assignees, shall or may re-enter, repossess, have hold, and enjoy said lands or tenements in his or her former estate for and during the life or lives of or so long term as the said person or persons upon whose life or lives the said estate or estate depends shall be living, and also shall upon action or actions to be brought by him or them against the lessors, reversioners, or tenants in possession or other persons respectively, which since the time of said eviction receive the profits of the said lands or tenements, recover for damages the full profit of said lands or tenements respectively, with lawful interest for and from the time that he and they were outed of the said lands or tenements, and kept or held out of the same by said lessors, reversioners, tenants, or other persons who after the said eviction receive the profits of the said lands or tenements, or any of them respectively, as well in the case when the said person or persons upon whose life or lives such estate did depend are and shall be dead at the time of bringing of said action or actions, as if the person or persons were then living. From public law to public policy. Our government has reverted to the old ruler's law, with nobles and lords reigning over its loyal subjects. Judges, attorneys, senators, congressmen, and presidents have all accepted special titles of nobility and powerful positions in the privileged ruling class of America. This legal fraternity has taken over the reins of government and has maintained a monopoly over all three branches ever since. The original 13th Amendment is a profound challenge to the de facto government and legal fraternity that presently rules the federal United States and all its political subdivisions. The Supreme Court has declared the Agricultural Adjustment Act and National Industrial Recovery Act, which were major components of Roosevelt's New Deal legislation, unconstitutional in 1935. President F.D. Roosevelt, not to be derailed by the Supreme Court, under the authority of his declared state of national emergency, then demanded a reorganization of the entire federal judiciary, directly challenging the independence of the judicial branch of government as guaranteed by the Constitution. This precipitated a change in our American system of law from public common law to public international bankers' policy or private commercial law. The legislative bodies in America are now the sovereigns over the courts, executive officers, and its so-called U.S. citizens. Their function is solely to pass public policy statutes in the interest of the nation's principals and creditors, wherein civil statutes contain criminal penalties under an admiralty jurisdiction. The new and improved Supreme Court after FDR ruled that all cases will be judged under the negotiable instruments law. See Erie Railroad versus Tompkins, 1938. After this case, common law was officially blended with the procedures of equity. New federal rules of civil procedure took effect along with the Social Security Act of 1938. In the next 10 years, the Court of Common Pleas began to disappear, and virtually every American became a U.S. citizen by enrolling in the Social Security system. The sovereignty of the states and its respective state citizens was almost completely destroyed by this federal corporate socialist coup d'etat. Since the Civil War, the state has usurped its power from the American people through bureaucratic threats, duress, coercion, and manipulation of the economic and legal system. The state has been at war against the American people since then. The government bureaucracy took advantage of the civil disobedience and dissent to strip Americans of their sovereignty and have been chipping away at the limited authority and jurisdiction enumerated and placed upon the federal and state governments through the Constitution and Bill of Rights. In 1863, Lincoln declared a state of martial law and suspended the writ of habeas corpus in 1861 through the General Orders 100, known as the Lieber Code, or the Code for Government Armies in the Field. The code was authored by Francis Lieber, a jurist and political philosopher from Germany who was a professor of history and political science at Columbia College, currently Columbia University. Lieber assisted the War Department and President Lincoln in drafting legal guidelines for the Union Army. These guidelines became known as the Lieber Code. Under Article 4 of the Lieber Code, martial law is defined as follows. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and of the domestic administration and government in the occupied place or territory, and in the substitution of military rule and force for the same, as well as the dictation of general laws as far as military necessity requires the suspension, substitution, or dictation. The commander of the forces may proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. Lincoln was assassinated shortly after the end of the Civil War, and General Order 100 was never repealed, or peace was never officially declared to end martial law. Accordingly, Americans have been under a perpetual state of war with the United States and under military rule and occupation ever since. Under Article 2 of the Code, it states, martial law does not cease during the hostile occupation except by special proclamation, ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war, when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. The Constitution for the United States of America was originally written as a contract between the federal government in the District of Columbia and free white males of the 13 original incorporated colonies that became states of the United States of America. These are the only parties to the contract of organic law for the government, besides those who later became naturalized citizens. The United States and the United States of America mean two different things when speaking in legal terms or legalese. The free white men of their 13 original colonies ordained the Constitution for or on behalf of the United States of America, which were the 13 sovereign states at that time, and their posterity or descendants. After the war, Congress passed the 13th Amendment ending slavery and involuntary servitude. Then they passed the 14th Amendment, creating a new class of citizenship, the subject citizen, through denationalization. A subject citizen was a corporate citizen or a subject of the de facto military government now in operation. Now, for the first time, legal entities, i.e. corporations, limited companies, and partnerships, could become citizens under the 14th Amendment and have legal rights under this status. Denationalization, the act of stripping a national group of their nationality and political identity. An example of denationalization can be found in the 1947 Nuremberg trial of Ulrich Greffelt and others. During the proceedings, a reference was made to the war crime of denationalization, citing the policy of forcibly Germanizing some groups within the local population of occupied Poland. Among the groups so treated were Poles, Alsace-Lorrainers, and Slavons, as well as others deemed eligible for Germanization under German's People's List. Legal tender. Under the 14th Amendment, the validity of the public debt shall not be questioned. In 1862, during the Civil War, the issuance of paper greenbacks as legal tender and circulating medium of exchange occurred under our current monetary system. Under the pretext of the War Powers Act, Congress authorized the issuance of non-interest-bearing treasury notes and declared the bills of credit to be legal tender for all debts, public and private, with the exception of taxes on imports. The notes were deemed necessary to float the debt of the United States for the war effort. On June 3, 1864, Congress passed the National Currency Act, also termed the National Bank Act, to provide a national currency secured by a pledge of the United States bonds and to provide for the circulation and redemption thereof. This act recreated the central banking system as a national association, which later evolved into the current Federal Reserve banks. All private banknotes issued under authority of the act were issued and circulated the same as money, had to be redeemable at par value, 1-for-1 with the coin, and were declared to be tender for the payment of all debts, public and private, under Section 23. Pledging or hypothecating any of these notes in circulation under this act was prohibited under Section 37. On December 23, 1913, Congress passed an act to provide for the establishment of Federal Reserve banks, to furnish an elastic currency, to afford a means of rediscounting commercial paper, to establish a more effective supervision of banking in the United States, and for other purposes. The act is commonly known as the Federal Reserve Act. Some of the purposes for enacting the Federal Reserve Act were to 1. Collect 94% of the net earnings of the Federal Reserve banks under pretense of a franchise tax under Section 7. Legalize and extend a float on the debts by reducing the backing or reserve requirements to 40% of the notes in circulation and transaction accounts under Section 11. Authorize hypothecation of obligations including United States bonds or other securities which the Federal Reserve banks are authorized to hold under Section 14A, and establish branches in foreign countries or dependencies of the United States for the furtherance of foreign commerce of the United States under Section 25. It is important to understand the term hypothecation as stated in Section 14A of the Act. Under banking, offer of stocks, bonds, or other assets owned by a party other than the borrower as collateral for a loan without transferring title. If the borrower turns the property over to the lender who holds it for safekeeping, the action is referred to as a pledge. If the borrower retains possession but gives the lender the right to sell the property in the event of default, it is a true hypothecation. Securities. The pledging of negotiable securities to collateralize a broker's margin loan. If the broker pledges the same securities to a blank as collateral for a broker's loan, the process is referred to rehypothecation. Dictionary of Banking Terms, Fitch, page 228, 1997. Section 16 of the Federal Reserve Act, which is codified at 12 U.S.C. 411, declares that Federal Reserve notes are obligations of the United States. The full faith and credit of the United States was thereby hypothecated and rehypothecated to the lending institutions for the issuance and emission of bills of credit as legal tender for all taxes, customs, and other public dues. The paper in circulation and transactions accounts could then be inflated 60% and the purchasing power depreciated and reduced by an equivalent amount. The final nail in the coffin of lawful money in the United States was with the passage of the 192nd House Joint Resolution, HJR 192, Public Law 7310 in 1933. This resolution made it against public policy to require payments in gold or a particular kind of coin or currency or in any amount in money of the United States. Now that all lawful money has been removed from circulation, there can be no payment of debts, only novation and/or discharge. Novation is the act of substituting a new obligation for an old debt that replaces an original party with a new party. Every time someone pays for something with a Federal Reserve note, they have essentially created a novation, and that debt is transferred to an obligation backed by the full faith and credit of the United States. Discharge is any method by which a legal duty is extinguished by any of the following means: the payment of a debt or satisfaction of some other obligation, the release of a debtor from monetary obligations upon adjudication of bankruptcy, the dismissal of a case, and the canceling or vacating of a court order, and the release of a prisoner from confinement. The 16th Amendment to the United States Constitution allows Congress to levy an income tax without apportioning it among the states or basing it on the United States Census. This amendment exempted income taxes from the constitutional requirements regarding direct taxes after income taxes on rents, dividends, and interest were ruled to be direct taxes in the court case Pollock versus Farmers Loan and Trust Company, 1895. The amendment was adopted on February 3, 1913. The Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. In Pollock versus Farmers Loan and Trust Company, the U.S. Supreme Court declared certain taxes on incomes, such as those on property under the 1894 Act, to be unconstitutionally unapportioned direct taxes. The court reasoned that a tax on income from property should be treated as a tax on property by reason of its ownership, and so should be required to be apportioned. The reasoning was that taxes on rents from land, the dividends from stocks, and so forth burden the property, generating the income in the same way that a tax on property by reason of its ownership burdened that property. After Pollock, while income taxes on wages as indirect taxes were still not required to be apportioned by population, taxes on interest, dividends, and rental income was required to be apportioned by population. The Pollock ruling made the source of the income, ergo property versus labor, etc., relevant in determining whether the tax imposed on that income was deemed to be direct, and thus required to be apportioned among the states according to population, or alternatively indirect, and thus required only to be imposed with geographical uniformity. Dissenting in Pollock, Justice John Marshall Harlan stated, "When therefore this court adjudges, as it does now adjudge, that Congress cannot impose a duty or tax upon personal property or upon income arising either from rents of real estate or from personal property, including invested personal property, bonds, stocks, and investments of all kinds, except by apportioning the sum to be so raised among the states according to population, it practically decides that without an amendment of the Constitution, 2/3 of the House of Congress and 3/4 of the states concurring, such property and incomes can never be made to contribute to the support of the national government." Members of Congress responded to Pollock by expressing widespread concern that many of the wealthiest Americans has consolidated too much economic power. The United States Revenue Act of 1913, also known as the Tariff Act, Underwood Tariff, Underwood Act, Underwood Tariff Act, or Underwood-Simmons Act, Chapter 16, 38 Statutes at Large, 114, October 3rd, 1913, reimposed the federal income tax following the ratification of the 16th Amendment and lowered basic tariff rates from 40% to 25%, well below the Payne-Aldrich Tariff Act of 1909. The act also provided for the reinstitution of federal income tax as a means to compensate for anticipated lost revenue because of the reduction of tariff duties. The most recent effort to tax incomes, the Wilson-Gorman tariff of 1894, had been declared unconstitutional by the Supreme Court because the tax on dividends, entrance, and rents had been deemed to be a direct tax not apportioned by population. That obstacle, however, was removed by ratification of the 16th Amendment on February 3rd, 1913. The act provided in part that, subject only to such exemptions and deductions as are hereinafter allowed, the net income of a taxable person shall include gains, profits, and income derived from salaries, wages, or compensation for personal service of whatever kind and in whatever form paid, or from professions, vocations, businesses, trade, commerce, or sales, or dealings in property, whether real or personal, growing out of the ownership or use of or interest in real or personal property, also from interest, rent, dividends, securities, or the transaction of any lawful business carried on for gain or profit, or gains or profit and income derived from any sorts whatsoever. The income of couples exceeding $4,000 as well as those of single persons earning $3,000 or more were subject to a 1% federal tax. Further, the measure provided a progressive tax structure, meaning that the high income earners were required to pay at higher rates. It would require only a few years for the federal income tax to become the chief source of income for the government, far outdistancing tariff revenues. Less than 1% of the population paid federal income tax at that time. The United States Revenue Act of 1916 raised the lowest income tax rate from 1% to 2% and raised the top rate to 15% on taxpayers with incomes above $2 million. Previously, the top rate had been 7% on income above $500,000. The act also instituted the federal estate tax. The entry of the United States into World War I greatly increased the need for revenue. An excess profits tax was introduced and the modern estate tax was imposed. The act was applicable to incomes for 1916. The current Tax Payment Act of 1943 reintroduced the requirement to withhold income tax in the United States. Tax withholding had been introduced in the Tariff Act of 1913 but repealed by the Income Tax Act of 1916. The current Tax Payment Act compelled employers to withhold federal income taxes from workers' paychecks and pay them directly to the government on workers' behalf. At the time of the act, Social Security payments and a World War II victory tax were already being withheld. Maternity Act. Here's an excerpt from Are We Federal Children Owned by the Government by Dave Champion. In 1921, the Federal Shepherd-Towner Maternity Act created the birth registration, or what we now know as the birth certificate. It was known as the Maternity Act and was sold to the American people as a law that would reduce maternal and infant mortality, protect the health of mothers and infants, and for other purposes. One of these other purposes provided for the establishment of a federal bureau designed to cooperate with state agencies in the overseeing of its operation and expenditures. What it really did was create a federal birth registry which exists today, creating federal children. This government, under the doctrine of parens patriae, now legislates for American children as if they're owned by the federal government. Through the public school enrollment process and continuing license requirements for most aspects of daily life, these children grow up to be adults indoctrinated into the process of asking for permission from government to do all those things necessary to carry out daily activities that exist in what is called a free country. Before 1921, the records of births and names of children were entered into family Bibles, as were the records of marriages and deaths. These records were readily accepted by both the family and the law as official records. Since 1921, the American people have been registering the births and names of their children with the state in which they were born, even though there is no federal law requiring it. The state tells you that registering your child's birth through the birth certificate serves as proof that he or she was born in the United States, thereby making him, her, a United States citizen. For the past several years, a Social Security number was mandated by the federal government to be issued at birth. The state claims an interest in every child within its jurisdiction. The state will, if it deems it necessary, nullify your parental rights and appoint a guardian or trustee over your children. The subject of every birth certificate is a child. The child is a valuable asset which is properly trained, if properly trained, can contribute valuable assets provided by its labor for many years. It is presumed by those who have researched this issue that the child itself is the asset of the trust established by the birth certificate, and the Social Security number is the numbering or registration of the trust, allowing for the assets of the trust to be tracked. If this information is true, your child is now owned by the state. Each one of us, including our children, are considered assets of the bankrupt United States. We are now designated by this government as human resources or chattel. Some examples of the measures to which people of the states which accept the provisions of the Act may be subject include the forced registration of pregnancy, governmental prenatal examination of expectant mothers, restrictions on the right of a woman to secure the services of a midwife or physician of her own selection, the payment of subsidies out of federal appropriations, Insurance of mothers may be made compulsory. The teaching of birth control and physical inspections of persons about to be married may be required. The act has been found unconstitutional by the courts. It purports to vest in agencies of the federal government powers which are almost wholly undefined in matters relating to maternity and infancy, and to authorize appropriations of federal funds for the purpose of the act. In McCullough versus Maryland, they ruled that the act is invalid because it assumes powers not granted to Congress and usurps the local police power. In Hammer versus Dagenhart, in more recent cases, however, the court has shown that there are limits to the power of Congress to pass legislation purporting to be based on one of the powers expressly granted to Congress, which in fact usurps the reserved powers of the states, and that laws showing on their face detailed regulation of a matter wholly within the police power of the states will be held to be unconstitutional, although they purport to be passed in the exercise of some constitutional power. In the message of President Monroe, May 4, 1822, the act is not made valid by the circumstances that federal powers are to be exercised only with respect to those states which accept the act, for Congress cannot assume and state legislatures cannot yield the powers reserved to the states by the Constitution. In Harrison versus St. Louis and San Francisco Railroad Company, they ruled that the act is invalid because it imposes on each state an illegal option either to yield a part of its power reserved by the 10th Amendment or to give up its share of appropriations under the act. A statute attempting by imposing conditions upon a general privilege to exact a waiver of a constitutional right is null and void. And in Knickerbocker Ice Company versus Stewart, they ruled that the act is invalid because it sets up a system of government by cooperation between the federal government and certain of the states not provided by the Constitution. Congress cannot make laws for the states, and it cannot delegate to the state the power to make laws for the United States. The Maternity Act was eventually repealed, but parts of it has been found in other legislative acts. What this act attempted to do was set up government by appointment, run by bureaucrats, with re-delegated authority to tax, which in itself is unconstitutional. Once declared as unconstitutional by the Supreme Court of this nation in the past, it should be upheld in a court challenge today. Part 2, Adhesion Contracts. The issue of status in commerce is simply one of how we enter into contract. In doing business with the United States and or its agents, we are the source of commercial energy in any contractual relationship. Commercially, we are typically engaged in transfers for most transactions. Transfers are activities that take energy, goods, and services from one party, but no value or detriment is received in return. The nature of this oppression is mostly invisible. Americans are being forced into an economic and political slavery by an elite aristocracy and consortium of international banksters through unlawful foreclosures, forfeitures of property, and a war on crime and drugs. Why is it important to understand the nature of these invisible or adhesion contracts? Because when a commercial contract is in effect, the Constitution is irrelevant and doesn't apply. The Constitution cannot interfere with, obstruct, intervene, or otherwise restrain the execution or operation of commercial contracts. When a commercial contract is in effect, the Constitution, namely the Bill of Rights, cannot be held to interfere with or obstruct the execution of commercial contracts for either party. George Mercier, Invisible Contracts. Juristic institutions descend to the level of commercial game players whenever they enter into the world of commerce, so it can be argued that sovereignty takes a back seat under some circumstances. We the people have an unlimited right to contract guaranteed by the Constitution and the common law preceding it. We the people also live in a commercial culture dominated by commercial agreements and contracts whereby our freedoms, rights, and sovereign state citizenship has been contracted away. Every time you sign your name on a form, you are entering a commercial agreement that can bind you to perform as specified. Some of these contracts may be harmless, ergo renting a video, yet others may bind us in ways we do not fully comprehend, ergo long-distance phone companies bind you to the law of the District of Columbia. These are called adhesion contracts. Contracts must be voluntary in nature and fully disclosed to be enforceable. The parties must also be able to perform. Adhesion contract. A contract so heavily restrictive of one party, ergo U.S. citizen, while non-restrictive to the other, ergo the government corporation, that doubts arise as to the voluntary nature of the contract. Take it or leave it basis, weaker party has no realistic choice as to its terms. Did you realize that when you completed and signed the Form 1040 tax return, you volunteered into the jurisdiction of the federal United States government, admitted being a corporate person and a federal government employee, agreed to abide by all the rules and regulations of the Internal Revenue Code, and therefore became subject to the state and federal income tax? Adhesion contracts do not bind the citizen to a commercial contract. Without the 6 elements of a valid contract, none exist. Public Law number 95-147, 91 Statutes at Large, 1227, October 28, 1977. U.S. citizens are bound by many adhesion contracts, including voters registration, marriage and business licenses, incorporation papers, selective service registration, postal addresses, bank accounts, credit cards, tax returns, social security numbers, drivers and vehicle license, and subject to tens of thousands of statutes. Here are a few examples of the hidden nature of these contracts and how they impact your freedom and life. Social security number. The completion of the SS5 application requesting an SSN creates a taxable franchise clothed with multiple layers of jurisdiction benefits. Therefore, SSN holders enter into a commercial setting, thus any enrichment and or gain is taxable. Voters registration. This is an unrevealed private contract obligating the voter or resident to pay municipal, county, and state bonds via the property tax, i.e. trustee fees, and a state income tax. Voters have also unknowingly given their power of attorney to the state. Electors are not bound to a contract or a political party. Electors are sovereign state citizens with allodial property in any state. Marriage license. This is an unrevealed private contract of the state who is a legal third party to your marriage, wherein they have control over the product, i.e. children, or the disbursement of community property via divorce. The state gets the power to take away your children if they deem it necessary for any reason. Do you want the government in your bed telling you how to raise your children? The doctrine of parens patria gives the state supremacy over parental rights. Business licenses. This negates your common law right to work in the profession and skill of your choice or talent. Do you need permission from the government to go to the bathroom as well? Free yourself from permission to contract when you have the unalienable right to contract. Incorporation. Your for-profit or non-profit business with limited liability for the payment of debt is a benefit from the government which costs the private individual 100% ownership and control over the corporation. Corporations are creations of and chartered by the state. When you are incorporating, you are now working for a government protected enterprise and subject to all the rules and regulations thereof. When the churches incorporated, they lost not only their sovereignty and independence, but their First Amendment rights to freedom of religion as well. Don't make the same mistake. Consider other legal structures that preserve common law rights. Non-profit corporations. Non-profits are owned and controlled by the IRS and its foreign principals and creditors. If you're working in the non-profit sector, the Federal Reserve and its principal creditors are your bosses. They don't give grants and funding away without receiving control over the agendas of these organizations, some of which can be well-meaning. Selective service. Registration is for U.S. citizens only. If you place your signature on that private contract, you are bound body and soul to it. The government corporation owns you completely. They decide whether or not your teeth need pulling, not you. You have no choice once in military service. The draft is voluntary servitude. Postal addresses. Utilizing zip codes and 2-digit state abbreviations are private contracts for federal government employees. Having or using a zip code supports the presumption that you are indeed a federal employee subject to the income tax and the Form 1040. Domestic mail is within the federal United States. Non-domestic is without the federal United States, between the sovereign state citizens and the state. Bank accounts. This is one of the most insidious. Commercial contracts with banks are interstate merchant and commercial instruments. And likewise are the individuals who experience profit and gain from any commercial contract they enter with a bank. Although bank accounts are not exclusive equity jurisdiction attachments, they are conclusive evidence of the account holder's interest into interstate commerce. Unknowingly, when you open a checking account or receive a credit card, and signed your name on the bank signature card, you entered a contract with a bank, which is also under contract with the Federal Reserve System, who has in turn contracted the IRS to collect taxes. In Davis versus Elmira Savings, the Supreme Court ruled, national banks are instrumentalities of the federal government created for a public purpose, and as such necessarily subject to the paramount authority of the United States. The word instrumentality means an equity relationship in which nationally chartered banks are an instrumentality of the Federal Reserve, and any profit or gain experienced from a bank carries with it the same force and effect as if the government created the gain themselves. Banking is not a substantive right, and if direct financial profit and personal gain is experienced, it can invoke an excise tax liability. This relational effect is known as the instrumentality doctrine. Black's law illustrates this point under the instrumentality rule. Under this rule, corporate existence will be disregarded where a corporate subsidiary is so organized and controlled and its affairs so conducted as to make it only an adjunct and instrumentality of another parent corporation. Under the instrumentality doctrine, the local bank as a legal entity fades away in significance as if it was transparent, and the Secretary of Treasury is the real entity you are entering into a commercial agreement with. Originally applicable only to nationally chartered banks, instrumentality doctrine has since been expanded under the Federal Reserve Act of 1913 to include all state and federally chartered member banks of the Fed, member of the FDIC, FSLIC, and SIPC. More recently, under the Frank-Dowd Act, this doctrine now includes all financial institutions where there is a federal regulatory interest in them. This includes brokerage firms, credit unions, insurance companies, and pension funds. That a national bank is an appropriate means to carry into effect some of the enumerated powers of the government, and that this can be best done by erecting it into a corporation may be established by the most satisfactory reasoning. It has a relationship more or less direct to the power of collecting taxes, to that of borrowing money, to that of regulating trade between the states, and to those raising and maintaining fleets and armies. And it may be added that it has the most important bearing upon the regulation of currency between the states. It is an instrument which has been usually applied by governments in the administration of their fiscal and financial operations. Joseph Story in Third Commentaries on the Constitution 134. Internal Revenue Service, IRS. Responsibility for the administration and enforcement of the revenue laws is vested with the Secretary of the Treasury pursuant to U.S.C. Title 26, Section 7801. By delegation, the IRS is vested with the tax collection responsibilities for the Secretary. See Donaldson versus United States, 400 U.S. 517 at 534, 1917. This chain of contracts gives authorization to the IRS to access information about your accounts, lien your assets, snoop into your records, garnish your wages, and subject you to the IRC, Internal Revenue Code. By not comprehending the power of contracts, you have unwittingly waived many of your rights by simply signing your bank signature card. We the people fall into this trap many times, creating a lengthy paper trail of presumptive evidence through these adhesion contracts, which are used to establish jurisdiction and to establish facts that can and will be used against us in a court of equity or admiralty. Presumption, an inference in favor of a particular fact, a rule of law by which finding of a basic fact gives rise to existence of presumed fact until that presumption is rebutted. There are many other adhesion contracts besides the one discussed above. An adhesion contract is one in which the state legislature or the Congress of the Federal United States government was acting as your agent or legal representative to bind you to their contract. 4 types of adhesion contracts have attached themselves unknowingly and often unwillingly. Interest, tax, statutes, and treaties. As an American sovereign state citizen, the Constitution offers no protection once you voluntarily entered into contract, having waiving your rights in exchange for any government privileges or benefits. A U.S. citizen is presumed bound to these adhesion contracts. They are as valid as if you signed each one yourself. Only a sovereign state citizen is not presumed bound to these adhesion contracts. Adhesion contracts entered unknowingly, unwillingly, or unintentionally can be nullified by declaration in the form of an affidavit, which is part of our SPC or redemption process. A U.S. citizen may rescind or revoke any adhesion contract they've entered into unknowingly and unwillingly to clear their name of all legal disabilities and become sui juris, free man or woman. A U.S. citizen may also argue that the signature on the contract never existed because there was not full disclosure. Rescind, to abrogate, annul, avoid, or cancel a contract, nullify a contract by the act of a party. Revoke, to recall authority or power previously conferred, to annul an act by calling or taking it back. Once you can determine your citizenship, the government may presume to know who you are, but they cannot tell you who you are. To be a sovereign state citizen, you must eliminate all presumptions that you've entered into contracts that bind your performance to them. State courts were federalized in 1982 under equity, amity, maritime jurisdiction, thus have no general jurisdiction unless there are unrebutted international adhesion contracts still in force over a sovereign state citizen. Sovereign state citizens must be tried in a federal court under the diversity of citizenship jurisdiction. You have the right to see any and all contracts. You have the right to get information the government may have about you through the Freedom of Information and Privacy Act request. You have the right of discovery in a court proceeding. All contracts must be entered into knowingly, willingly, and voluntarily to be enforceable in any jurisdiction. Be careful when signing your name and enter into contracts unseen. Your name is your property, just like your fingerprint. Your name is also your power of attorney, providing you haven't given it to someone else to legally act on your behalf. Henceforth, whenever signing your name, read the fine print. Ask for the hidden contracts and always add a citation from the Uniform Commercial Code under your signature. Example, UCC 1-308. Contracts we enter into today overrule and extinguish contracts entered into a previous era. The principle of law that this is based on is called the merger doctrine. Prior oral negotiations are nullified as those negotiations merged into confluence of a written contract. See Price versus Block. Part 3, Jurisdiction. The fact that under the Organic Act of 1871, the U.S. has been organized and operating as a municipal corporation and partnering with private corporations and trading companies, it loses its sovereign immunity and descends to the level of a mere corporation. This applies to all state franchises that have incorporated as federal enclaves and issued general obligation bonds and trading in trade receivables and payables through the Court Registry Investment System, or CRIS. The Clearfield Doctrine is stare decisis upon all courts and imposes that an entity cannot compel performance upon its corporate rules unless it, like any other corporation, is the holder in due course of some contract or commercial agreement between it and the one in whom it demands for the performance are made, and is willing to produce said document and to place the same into evidence before trying to enforce its demands. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private corporate commercial paper, i.e. Federal Reserve notes and securities, are concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separated from government. See Clearfield Trust Company versus United States, 1942. Due to the securitization of all debts, the Department of Treasury, DOT, becomes the secondary obligor on all notes, bills, and bonds attached to the original promissory note. The information is then communicated to the Bureau of Public Debt that keeps a daily account of the national debt. So-called lenders can go to the DOT to demand payment for uncollected debts to repay their creditors. The DOT uses your signature on the promissory notes as an asset to issue debt instruments to prepay their expenses. Once one is able to uncover the fraud and deception that is occurring, one can use one or more of the 10 real defenses to discharge the obligation. The juristic person, or the straw man, was registered upon the application for one's birth certificate and has been declared insolvent and is being administered under involuntary receivership. The only way to free yourself as surety for these debts and obligations is through redemption SPC process and enact a bankruptcy proceeding for the straw man in U.S. Bankruptcy Court to get complete discharge of any and all debts. All states have adopted provisions of UCC Article 3, Section 305A of the Uniform Commercial Code, whose provisions deal with insolvency proceedings. An authenticated discharge from a federal bankruptcy judge must be honored by all states by operation of law. Congress have abrogated the state's sovereign immunity in bankruptcy proceedings. See Hood versus Tennessee Student Assistance Corporation. States, whether or not they choose to participate in the proceeding, are bound by a bankruptcy court's discharge order no less than other creditors. See New York versus Irving Trust Company, 288 U.S. 329. In adopting the bankruptcy clause, Congress was able to enforce discharge orders. There was also provision granting federal courts the authority to release debtors from state prisons. States agreed in the plan of the convention not to assert any sovereign immunity defense they might have had in proceedings brought pursuant to the laws on the subject of bankruptcies. Blatchford, 501 U.S. at 779. Color of law. The Constitution and the Bill of Rights are still the supreme law of the land. Although many people pay lip service to the state and federal constitutions, many more Americans have never read it, and the government officials have pledged superficial allegiance while routinely violating its principles and intent. 42 U.S.C. Civil action for deprivation of rights. Every person who, under the color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in any action at law, suit, inequity, or other proper proceeding for redress. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. All acts of the state legislature and the U.S. Congress must be consistent with and derived from the Constitution for the United States of America. A colorable law or statute appears to be law, acts like a law, but ultimately does not have the authority of law. Many statutes, administrative laws, and rules and regulations present the appearance of a legal right, but are without lawful substance. It is through colorable statutes and administrative law that corrupt shadow governments are created. Colorable law is that which is in appearance only and not reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. Colorable law, commercial law, and political law are synonymous terms. These laws are nothing more than bylaws of the corporation that regulates the business or commerce of the government agency, international or domestic corporation. They are listed variously as political code, commercial code, statutes, public policy, and as such are all under color of law. The Federal United States is a foreign corporation. The U.S. Congress writes bylaws their members, i.e. U.S. citizens, must obey. The real substantive laws of a state, which are judicially enforceable, although they may appear under the listing of statutes as civil code, penal code, or variations thereof, may generally be thought of as contained within the organic law as codified common law. Acts performed under color of law by any federal, state, or municipal government or its employees may include illegal acts done by government officials, bureaucrats, employees, etc., not only within, but also without and beyond the limits of their lawful authority. These acts are illegal, so when an official steps outside the bounds of their lawful authority, they become personally liable for the offense, as would any private citizen. The appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law, and made possible only because the wrongdoer is clothed with the authority of state, is action taken under the color of state law. 42 U.S.C. Any government official, employee, or agent of the corporate government, police officer, county sheriff, judge, magistrate, attorney, congressman, senator, bureaucrat, IRS agent, federal agent, employer, including the President of the United States, who conspires to deprive a sovereign state citizen of any right or privilege secured by the respective state constitutions, federal constitution, and Bill of Rights, or acts improperly under the color of law, is subject to criminal prosecution in both their individual and official capacity. The sovereign state citizen has powerful, lawful tools to protect one's unalienable rights and make all government accountable to the Constitution and the law of the land. A thorough understanding of the law and how the legal system actually works is required to defend one's rights against the intrusions of government. Public officials are not immune from suit when they transcend their lawful authority by invading constitutional rights. See AFL-CIO versus Woodward. 18 U.S.C. Conspiracy against rights of citizens. If two or more persons conspire to injure, oppress, threaten, or intimidate any citizen in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined not more than $10,000 or imprisoned not more than 10 years or both. And if death results, they shall be subject to imprisonment for any term of years or for life. 18 U.S.C. Deprivation of rights under color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant of any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the constitutions or laws of the United States, or to different punishments, pains, or penalties on account of such inhabitant being an alien, or by reason of his color or race, then are prescribed for the punishment of citizens, shall be fined not more than $1,000 or imprisoned not more than 1 year or both. And if death results, shall be subject to imprisonment for any term of years or for life. There is no risk of criminal prosecution when one in good faith challenges an agency. Casey versus FTSCA. Uniform Commercial Code is colorable law, and is not law, but gives the appearance of law and is upheld by the courts as law. This colorable law is known only to judges and licensed attorneys, although it was designed to protect the common people from unscrupulous merchants and bankers. Recent statutes have been passed which allow the government to seize and sell immediately the real and personal property and private papers of accused drug dealers before the cases even go to trial. Even more shocking is that now these laws are now being used in other cases where the government feels the need to inflict immediate and disabling hardship on the defendant in order to keep him or her from presenting a viable defense. Fortunately, these statutes have been declared unconstitutional by the Supreme Court. There is no liberty if the power of judging be not separated from the legislative and executive powers. No legislative act contrary to the Constitution could be valid. Alexander Hamilton. There are no longer any genuine Article III courts except those being formed by dedicated patriots throughout the U.S. The judges no longer have the powers and immunities of Article III judges, but have only ministerial powers in legislative tribunals as per Article I, or the territorial courts of Article IV. Article III courts were created by the Constitution and are legitimate courts of the land based on substance and law. The laws passed and the courts created under the exclusive legislative authority of Article I are not required to be consistent with the Bill of Rights or the common law. America is no longer a nation of laws, but of petty tyrants operating as bureaucratic tribunals, ergo construction contractors board, building and planning departments, licensing agencies, etc. A statutory jurisdiction has been in effect and created without constitutional authority. Justice and common law are not available unless you know how to invoke them. There's a bit of magic, a lot of study and preparation, and a waving of the magic wand of words and citations. As colorable law, the UCC is based on negotiable instruments, a medium of exchange not based on real substance, paper money, checks, credit, Federal Reserve notes, or other securities. The common law is based on substance, gold and silver, while Uniform Commercial Code is based on bankruptcy, FRNs. The Negotiable Instruments Act of 1938 has in effect bound all corporate entities of government together along with their franchises, i.e., U.S. citizens, in a vast system of commercial agreements. Everyone in this system is a statutory law merchant dealing in negotiable paper under limited liability for the payment of debts. This is what has dramatically altered our court system from one under the common law to a legislative, administrative, tribunal system of commercial, colorable law based on negotiable paper. This is how the U.S. citizens are held to the letter of every statute of federal, state, county, and municipal government unless they exercise the remedy provided within the UCC and through our redemption SPC process. All contracts since the New Deal and the federal bankruptcy of 1933 have been colorable contracts. Ever since America went off the gold standard in 1935 and declared FRNs as fiat currency or legal tender, we've been using the colorable consideration of FRNs instead of gold to negotiate these colorable contracts. The term colorable was changed to commercial, and an unconstitutional statutory jurisdiction was created in the courts to enforce these colorable contracts. This statutory jurisdiction is legislative rather than judicial in nature. Thus, the equity admiralty courts were merged with the common law courts to enforce these commercial agreements. This is obviously unconstitutional, as it dissolved the independent judiciary and created a jurisdiction not authorized by the Constitution. Without a legitimate payment of debts and contracts based on gold or silver, a system of colorable law was introduced that brings every American into a commercial contract with the corporate government monopoly, state socialism. Although our unalienable rights cannot be taken away from us, we may contract them away at will. All this has been accomplished by carefully orchestrated plans and practices of the Federal Reserve Bank and through the quiet introduction and implementation of the Uniform Commercial Code in all 48 corporate states in U.S. possession. Texas was the last state to adopt the UCC in 1967. The entire taxing and monetary systems are hereby placed under the UCC, the Federal Tax Lien Act of 1966. Under the UCC, we the people are obligated, as in any commercial agreement, to the terms and conditions of the contract, but we are unaware of the terms of this contract, which are scattered and hidden in millions of pages of regulations, statutes, codes, and ordinances at the federal, state, and local levels. Most of us are even unaware that such an agreement exists. The prevailing benefit being given to the American people is the privilege of discharging debt with limited liability instead of actually paying debt with lawful money. You cannot be sued for not paying your debts. If you exercise the benefits of a contract, it is presumed that you intend to meet the obligations associated with those benefits. If you can get everybody to exercise the benefit, then you've got people obligated, thus under federal jurisdiction. Every system of civilized law must have remedy and or recourse. Remedy, a way to get out from under that law. Remedy means rights with or without tribunal, UCC 1-201. Remedies are to be liberally administered, UCC 1106. Recourse, if you have been damaged by the law, you can recover your loss. The Social Security number is the foundation instrument contract upon which the courts presume to have standing to send you a presentment, i.e. citation, ticket, fine, penalty, or invoice. When you are forced to use a benefit or privilege of the government, ergo postal service, highways, public utilities, welfare, city services, limited liability, FRNs, etc., you must first reserve your rights under the common law, not to be bound by any contract or commercial agreement that you did not enter into knowingly, voluntarily, and intentionally. See UCC 1-207. For U.S. citizens, this is a remedy against the tyranny inherent in the American courtroom today. Once the court has acknowledged your reservation of rights in the common law, you must design a strategy for your own affirmative defense. Affirmative defense, one that serves as a basis for proving some new fact, whereby a defendant offers new evidence to avoid judgments against him or her, derived from the common law demur. There is a remedy and recourse to be found in this colorable law. There are specific sections in the thousands of pages of the UCC that can be used to assert our common law rights. More in-depth study is required to develop a personal strategy toward using these remedies in an actual court situation. Also, find references to these remedies and recourses in the state law as well. Liberty lies in the hearts of men and women when it dies there. No constitution, no law, no court can save it. Where do you stand, citizen? Judge Learned Hand, 1961. UCC-1207. The making of a valid reservation of rights preserves whatever rights the person then possesses and prevents the loss of such right by application of concepts, waiver, or estoppel. A reservation of rights can only reserve a right that is existing. The failure to make a reservation thereof causes a loss of the right and bars its assertion at a later date. Waiver, an intentional and voluntary surrender of some right. Estoppel, a restraint, arises where a person has done some act that the policy of law will not permit him to deny or will not permit a certain argument because it would lead to an unjust result. Without prejudice implies that no special privileges, benefits, or title of nobilities exist. Any expression indicating an intention to preserve rights is sufficient, such as without prejudice, under reservation, or with reservation of all our rights. Anderson on the UCC. The code is complementary to the common law, which remains in force, except where displaced by the code. A statute should be construed in harmony with the common law, unless there is a clear legislative intent to abrogate the common law. Some affirmative defenses. UCC 1-103. Prove duress or fraud if you were told that you had to perform such and such an act, or that you were influenced to believe it was illegal not to perform such and such an act, or that you were coerced or misled into believing that you had to enter such and such a contract. Prove the government's fraudulent behavior and false presumptions that any contract with the government must be under threat, duress, or coercion. Prove that the government is acting in a fraudulent manner by claiming to be bankrupt. UCC 2-302. Prove an unconscionable contract or clause is void, especially for consumers. Unconscionability has generally been recognized to include an absence of meaningful choice on the part of one of the parties, together with contract terms which are unreasonably favorable to the other party. Judge Wright. UCC 3-305. Government officials have a duty to inform you of your rights or remedies. Government officials have a responsibility to tell you of any pending responsibility on your part and to inform you of all the terms of the agreement pursuant to UCC 3-305. Produce all documents held in due course that provide any legal disability. So if you refuse to participate in the bankruptcy actions of the federal United States government, liability discharges, presentment denied or refuted, pursuant to UCC 3-305. Presentment, a written accusation of the crime by a grand jury under the common law, an international admiralty maritime contract, notice of deficiency, traffic ticket, bill, or adhesion contract. UCC 3-401. No one is liable on an instrument unless and until he or she has signed it. UCC 3-403. You have a right to be told who the principal is. UCC 3-505. Insist on a presentment, notice of deficiency or contract without dishonor and refuse for good cause. Demand to see the original international contract or presentment with the federal government, evidence that I am on a federal U.S. citizen, a federal employee operating a vehicle for commercial purposes, etc. Do not admit to the contract. Demand they produce the signed authorization. Presentments must be duly made based on proper foundation, recorded, perfected, negotiable instrument. UCC 3-505. Counter demands by a party to whom presentment is made. The party to whom presentment is made may, without dishonor, require exhibition of the instrument that created the liability, reasonable identification of the person making presentment and evidence of his authority to make it if made for another, and that the instrument be produced for acceptance or payment at a place specified in it, or if there be none, at any place reasonable in the circumstances, and if signed, receipt of the instrument for any partial or full payment and its surrender on full payment. 2. Failure to comply with any such requirements invalidates the presentment, voids it, but the person presenting has reasonable time in which to comply, and the time for acceptance or payment runs from the time of compliance. UCC 3-505. The presenter or his authorized agent may treat the presentment as dishonored if the person to whom presentment is made makes counter demands which are not authorized by UCC 3-505, or places unreasonable conditions on demands authorized by that section. If counter demands are proper, the presenter must comply with them, and the code gives a reasonable time in which to respond. Correspondingly, until there is such compliance, there is not further duty upon the other person to whom presentment is made, and the time for acceptance or payment runs from the time of compliance. UCC 3-601. Discharge any presumed liability if you've been given or find no remedy or recourse. UCC 3-608. Revoking your agreement in colorable law. UCC 2-609. Demand assurance and due performance as it relates to promises made. Like demand assurance before entering into a contract that the purchasing power of FRNs will be as good at the end of the contract as the ones you pay in the beginning. Obviously, they cannot guarantee that. Did they refuse or did you? A no interest contract is void and unenforceable. So those are a few of the affirmative defenses that you can use to void a colorable contract. That is the end of our presentation today. Hope you guys enjoyed it, and I hope you learned a lot. We'll be seeing you for the next webinar. Thank you.
Okay, everybody. I truly hope that you got something out of what we brought to the table this afternoon. And keep in mind, this is part 4. We are coming back with part 5. We got a lot of stuff to cover when it comes to this kind of stuff. We got to deal with your bonds. We got to deal with your right to travel. We got to all of this stuff. There's a ton of stuff that you have to deal with. We got to deal with the banks. We got to deal with the foreclosure, your affidavits, all of this stuff. We are bringing to the table to let you know what we have to offer and what we stand behind and the things that we use to assist people across the United States and other parts of the world. Okay, but anyway, don't forget www.newdataelimination.com or www.tarhakadataelimination.org. Y'all stay tuned for part 5, and we'll be getting out to you as fast as we can. The number to reach me is area code 904-303-9061. That's 904-303-9061. We're available to communicate from 9 a.m. Eastern Standard Time all the way up to 6:45 p.m. Eastern Standard Time. We're doing that 7 days a week. Now, you know we do an online radio broadcast. Me and Dr. Walter Williams, and later on we'll be bringing in other guests. If we live on the air, we can't, I can't do 2 things at one time. But anyway, hope you got something out of this. Hope you took some good notes. Read over it, look over this video over and over and over. Make sure you go back, catch part 2, 3, 2, and 1 that we did a few years back. I'm Tarhaka. Y'all have a nice day.